from the daily list. Item number 1.
My Lord, this is pertaining to Nehu, my Lord. The student agitation going on in. So, my Lord, I have received instruction, I have placed it, my Lord, to lots of manipulations. Some measures have been adopted by the central government, my Lord. Well, the three aspects, my Lord. A committee has been constituted. The committee is to submit a report within 15 days, my Lord. Secondly, acting Vice Chancellor has taken over, my Lord, the senior most Professor Saha. And third, my Lord, the Vice Chancellor has gone on leave till 29th, my Lord. So once the report is submitted by the inquiry committee, my Lord, inquiry committee consists of very senior professors, my Lord. One was the former chairman of the UGC, my Lord, and the other member is the former Vice Chancellor of Assam University.
Who's for the petitioner?
My Lord, Mr. P.U.Bin is indisposed today. So if we can take up this matter after we receive the report from the this committee, my Lord, inquiry committee. They are yet to submit in 15 days.
What does the learned advocate general say?
Lord, the state has also appealed to the students to call off the hunger strike because their health is the condition, and we want the academic schedule to come back. And the measures have been taken. Now VC has gone on leave. There is another acting VC, and the committee has also gone. Your Lordship, in last order, has also directed communication of the order to the students' union, my Lord. So if the students' union come, because their grievances are being addressed by the central government, and their health condition is also not, I'm instructed to say, is not good, my Lord, and even Chief Secretary, DGP, they have visited and they have tried to persuade the union to call off the hunger strike, my Lord. Their grievances are being looked into and are being examined, my Lord, so that academic normalcy and
this winter, so cold.
And the winter is also there, my Lord. So through your Lordship, state is appealing to them to call off the hunger strike, and as their grievances are being addressed and being looked seriously by the central government, my Lord.
My Lord, in fact, there were another step taken, my Lord.
Copy has not been sent to the students' union
No, my Lord.
of this, your central government's order.
But the direction was to the petitioner to communicate to them, my Lord.
We will communicate, my Lord. If the steps have not been taken, my Lord, we will immediately communicate to the. But this central government order has been communicated to the union. I am instructed to say, my Lord, the central government, these orders, constitution.
These orders.
These orders, my Lord. Probably your Lordship's order, I am not aware whether
Not.
these orders have been communicated.
These are they are aware, my Lord.
And this, our order,
That I am not.
have you communicated?
No, my Lord.
No. Then for what purpose you have filed this application?
To communicate.
My lord, actually, this we file as suo motu. So we in the last order.
In the meantime, the petitioner
Yes, in
shall
the last-
communicate.
My lord, in the last order, it is stated that we will wait after the direction of anything that is done from the state or the central government. So in the last order, they gave that they have created these two-member committee for the inquiry report. So only after this, my lord, we will this court will intervene regarding the matter.
No, we will communicate, my lord. It is not communicated.
No, they have gone on strike. They are on hunger strike.
They are on hunger strike.
Yes.
They must be belonging to the union.
My lord. Yes. The students' union of the university, my lord, the members of the union have gone on strike, my lord.
So that is the major cause of concern.
That is the major cause of
They are
concern.
continuing hunger strike.
But in this weather, my lord, they are in the open on hunger strike, my lord, and weather is also very inclement now, my lord.
We will keep it day after tomorrow. Communicate this order to them. We have to hear them.
Will communicate. Yes.
And now they are the ones who are creating the problem. Either not the other person. Because of the students' agitation, they have been activated. But their major concern is that continuing hunger strike, as he says. The student union has an office.
Yes, my lord.
You paste a copy of this order on the office. That's
Sure, my lord.
Let me please, Your Lordship, my lord. I'm representing Nehu. Now, my lord, we have a acting vice chancellor in place. Now, our biggest concern right now, my lord, the students are still on strike. Their health condition, my lord. We have put up a, my lord, the medical team 24/7. Some of them even have been shifted to the hospital. So this is our biggest concern, Your Lordship. We are trying our level best, my lord, to persuade the student, my lord, to give up the hunger strike, my lord. But somehow, my lord, it is continuing still.
My lord, the main demand is for them to remove the VC. That's why this hunger strikes keeps on going on.
That is there, my lord. So far, BC is concerned, present BC, my lord, he has gone on leave till 29. And the senior most professor, my lord, now he is in charge.
Yes.
No, it is all right. As we have seen that many requests have been made to withdraw the strike.
Right.
They have not withdrawn the strike. And in between, this order of the central government comes.
Correct, my lord.
So they should be made aware of this order. Thereafter, what is the response?
Yes, but even we can, my lord, I mean, if we make the materials available, we can transmit it to the.
You affix it on their notice board, that's all. They must be having a notice board,
Yes.
Yes, yes.
that's all. No. Have notice of this. No. But what is their responsibility? They will just strike, but at the end of the matter.
Or your lordship, my lord, we can hand it over. One can be affixed in the notice board. One we can send it to the register, my lord, to
Union.
to give it to the union.
They will receive it.
We have a acting register now.
Yes, please take note. Learned Deputy Solicitor General of India, hands up to this court. A communication dated 19th November 2024, with which is attached an order dated 14th November 2024 of the Department of Higher Education, Ministry of Education, Government of India, to the following effect. This part. Paragraph. All learned counsel appearing today, including the learned Advocate General, the learned Deputy Solicitor General of India, and Mr. Sen representing NEHU, have expressed concern over the continuing hunger strike of a section of the students. Full stop. They are of the view that considering the fact that winter is setting in and it is becoming exceedingly colder, the chance of deterioration of health of the striking students is greater. With the passage of time, and that this hunger strike should end. Full stop. Furthermore, this communication of the central government should persuade them to call off the hunger strike. This would facilitate the resumption of normal functioning of the university. Paragraph. For us to pass any order, it is essential that our earlier order dated 13th November 2024 and the said communication of the Education Ministry dated 19th November 2024 along with the office order dated 14th November 2024 be made known to the Students' Union. Full stop. Paragraph. Copy motion. Probably you're sitting. When are you sitting away? When are we sitting away? 29 may not be there. Friday. This Friday. Accordingly, list this application once again on 22nd. Mr. Sen, appearing for the university, undertakes to ensure that a copy of the state communication and orders are affixed at a suitable place at the notice board of the university so that the students have knowledge of this order.
We can serve it on the students' union.
So in whatever way you do,
Lordship. Right. Only thing, my lord, these materials will be made available to me.
We'll give.
Immediately, my lord, in the course of the day.
Yes, now. Yes, please. Last order. Material and.
Item number 2.
Obliged.
Lord, state is in appeal against the order of learned single judge, my lord. The learned single judge, my lord, very short issue, my lord, then your lordship made. The learned single judge has quashed the order of the Deputy Commissioner, my lord, who was directed to dismantle the toll gate, toll which was being collected by local sardars from trucks which were carrying the minerals, my lord. This order of the Deputy Commissioner, my lord, was passed pursuant to the judgment and order of Division Bench of this Honorable Court, which held that the local sardars have no legal right to collect tolls from the trucks which are carrying the minerals and coal, my lord. And there is no right to collect toll from the trucks because neither under constitutional law nor under any law they have power to collect the toll, my lord. That order, my lord, was at page 71, my lord. This order 71A, my lord, is a typed copy, my lord. This is so, my lord, what has happened, my lord, now, this order was, after quashing of this order, my lord, now there has been mushrooming of toll gates by local sardars all over Meghalaya, my lord. Because they are collecting, this was
This date is obliterated. What is the date? 28 June, which year?
at 16, my lord. It's a 16 order, my lord. And that part is, my lord, clear from impugned judgment 28/6/2016, my lord. We filed the appeal, my lord. Matter was heard by the earlier bench, but the judgment could not be delivered and the Honorable Chief Justice retired, my lord, earlier. The state is concerned with the fact, my lord, that after this,
It was heard before Justice Vaidyanathan.
Justice Vaidyanathan, my lord, that matter. And we have filed our written submissions also. If your lordship will kindly see. Order of 22nd February 2024, my lord.
My brother was there in the bench,
Yes, my lord, just
but you have to apprise me, you know.
again, my lord, I have to do that, my lord. The matter has to be heard afresh, my lord. Only one submission I was making, my lord, whenever your lordship.
Where is the impugned order?
The impugned order is that the impugned order was passed on 26/6/2022, my lord.
Page?
Page 35, my lord. And my submission, if your lordship will kindly see, page 41, paragraph 16, my lord. First submission, my lord, in paragraph 16 is that identical writ petitions seeking collection of toll has been dismissed. Second submission was, my lord, in paragraph 17, my lord, that the Mines and Mineral Development and Regulation Act will prevail over all customary practices, my lord. And after recording all this, my lord, in 23, my summary is there, my paragraph 23 at page 44, my lord. Learned AG has submitted. May I read paragraph 23, my lord? Has summed up his argument by submitting that firstly, the petitioner has no legal right under the law Secondly, all collection of tolls has to be backed by law with reference to provisions of Article 19(1)(d) and G. And lastly, the law laid down in Meghalaya Commercial Truck Owners is not applicable to the case so far as collection of tolls from mineral laden vehicle is concerned. And finding, my lord, of the learned single judge is at page 51, paragraph 35, my lord. Page 51, paragraph 35, my lord. The learned single judge accepts my argument, my lord, but still chose to quash the order of the Deputy Commissioner, my lord. Paragraph 35, page 51. There can be no quarrel with the proposition of law laid down by the Honorable Supreme Court in all the Master Students Union, paragraph 146, apart from elaborating 9(1)(d) of the 6th schedule, latter part of the paragraph, and import of para 2 to say that said provisions contemplates that any law made by district council or regional council which is repugnant to any law by the state shall be void. However, the reference of the respondent to the state or central law in the context was only confined to Mines and Mineral Development and Regulation Act 1957 and rules made thereunder applicable to the state of Meghalaya. As pointed out, the collection of customary toll by the petitioner is not confined only to mineral laden vehicle, my lord, but also to goods laden vehicle. My lord, I have shown the order of magistrate where at page 71, the dismantling of gate was in respect of the trucks carrying the mineral, from which 200 rupees was being collected by the local Sardar. And your lordship is aware that mines and minerals are controlled and governed by Mines and Mineral Development Regulation Act. So the learned single judge, my lord, in my humble submission, has erred in holding that collection of customary toll is not confined only to mineral laden vehicle. Impugn order is, my lord, is only in respect of mineral laden vehicle, my lord. So, my lord, in view of the clear and unequivocal proposition of law, my humble submission is that at least the order of learned single judge may kindly be stayed, because what has happened that after this order, my lord, so many check gates have come up and they are virtually extorting money from the trucks carrying minerals, my lord. And there is some urgency, my lord, because there was, after this order, my lord, the bench was not available for some time. We went to the Honorable Supreme Court seeking transfer of this writ appeal to the Guwahati High Court, but Justice Vaidyanathan came to be appointed as the Chief Justice of this court, and then matter was heard. But unfortunately, judgment could not be delivered, my lord. So I was praying that either your lordship kindly stay this order, because my order of dismantling is in respect of the toll gate which is collecting the toll from the trucks which are carrying the minerals, my lord. Or your lordship may direct the Sardar to maintain the details of the toll.
Advocate General, in the midst of hearing of the appeal,
Yes, my lord.
unless there is change of circumstances,
I bow down. I bow down, my lord.
the court cannot insert an interim order when there is none.
Yes, my lord. I quite see what is.
You can bring to our notice change of circumstances, multiple gates coming up, etc. Then you have to make an application.
Yeah, I bow down, my lord. We will move.
We will try to hear it out as soon as possible.
Yes, my lord.
A brother was there on the bench.
Yes, my lord.
But the thing is, this Mineral Act,
Yes, my lord.
this mineral, mines and minerals, it's in the union list or state list or current?
It's in union list, my lord. Mines and Mineral Development and Regulation Act comes under entry 66 list 1, my lord, and it occupies the entire field, my lord. If I give
No,
the,
but it is not in the state list also.
it is not in the state list also, my lord. except for taxation part, my lord, your lordship has seen the other day
That judgment.
judgment. Taxation is within the realm or within the legislative competence.
9-member bench.
9 judges bench.
Where
my lord.
Justice Nagaratna deferred and the other
Yes, my lord. I'm grateful.
made a concurring judgment.
Yes, my lord. I'm grateful. So, but all other aspects are covered by, my lord, Mines and Mineral Development and Regulation Act, my lord. And in the context of Meghalaya only, my lord, there is a direct judgment of the Honorable Supreme Court. Because, my lord, before 2015 in Meghalaya, Mines and Mineral Development and Regulation Act was not being applied stricto sensu. And coal mining was taking place without permission of the central government, my lord. Ultimately, the case traveled to the Honorable Supreme Court, and on 6 July 2019, the Honorable Supreme Court settled the law
Yes.
in respect of Meghalaya in the judgment of the Honorable Supreme Court called All the Masa, and the citation, my lord, is that of that judgment is, my lord, (2019) 8 SCC 177, my lord.
And this mines and minerals.
Yes, Mines and Mineral within bracket Development and Regulation Act 1950.
8 perhaps.
Mines and Minerals within bracket below Development and Regulation Act 1957.
57. And this is under entry.
Entry 66, list 1, my lord. And the authority on, direct authority on this, my lord, in the context of Meghalaya is, of the Honorable Supreme Court is 2019 8 SCC 177.
You have just cited this.
Yes, my lord. So, your lordships may fix any date subject to your lordship convenience.
So this was being officially collected as customary toll.
This is being collected as customary toll, my lord.
By whom?
By the locals, by the agent appointed by local sardars.
Now, local sardars
Are the officials of Khasi Hill Autonomous District Council. They are all being regulated under the Autonomous District Council called Khasi Hills Autonomous District Council, my lord. KHADC in short form.
and council is created by an act.
The council is created under the paragraph 6 of the paragraph 6 of the schedule, my lord, of the Constitution of India, my lord. District council is created under Schedule 6 of the Constitution of India, my lord. They are all constitutional authorities, my lord. Sixth schedule of the Constitution of India, my lord, creates the autonomous district councils for governance of certain subjects.
I think an act also has recently been enacted, very recently, within 2 or 3 weeks.
Your lordship,
That is only one particular chief, traditional institutions, Kairim same chief, my lord.
I see.
by the district council, that act is enacted by the district council under the powers given under the 5th, 6th schedule of the Constitution of India, my lord. And on earlier occasion, my lord, the district council was also appointing the agents for collection of toll, my lord. That decision of the district council was challenged before the learned single judge. Learned single judge held that district council has no power to collect the tolls because that subject is not covered. The division bench matter was challenged by the district council before division bench. Division bench also dismissed the writ appeal of the district council, my lord. Even SLP was filed and that was also withdrawn, my lord. So to that extent, the issue with regard to the power of district council to collect the toll has been settled by this honorable court, my lord. They do not have the power. Our case is, if they do not have the power settled by the division bench, then their agents also, they do not have the power to collect the customary tolls, my lord. And any toll and tax has to be collected in accordance with law, my lord. Article 265 is very clear. Lordship may fix any date subject to your lordship's convenience.
How much time you are likely to take?
I will finish within 30 to 40 minutes max, my lord.
You?
I'll take some time, Your Lordship, subject to Lordship permission. It's involved a very important question of law. I defer the argument of my Lord AG. The issue is, my Lord, the customary rights of collecting tolls, local customary tolls. It doesn't fall under the MMDR Act. But I'll advance.
It may be voluntary, but you cannot enforce.
But I'll satisfy me. There is an enactment also passed by District Council under the Act, and not only my Sardarship, many Sardarships are collecting under the Act passed by District Council in the 6th schedule. But I'll satisfy me. If Lordship is subject to Lordship convenient, may the fix on 9, 10, or 11 of next month.
6th Friday. 6th Friday?
Yes, ma'am.
What? Maybe, but we oppose it. Learned Advocate General commences his argument in the appeal, but does not conclude the same. List is appeal for further hearing on 6th December 2025, marked at 12:30 p.m.
Grateful.
As the only matter in the list, only one. You write that on 6th December as the only matter in the list, marked at 12:30 p.m. The list of this bench, marked at 12:30 p.m.
Item number 3.
This is an appeal from the order of the London single judge, my lord. But on my personal ground, my lord, I'm praying for some time because my throat is still a week's time, my lord. So I should be okay, my lord.
You're for the appellant or respondent?
I'm for the appellant.
All right. On the personal ground of the learned Deputy Solicitor General appearing for the appellant, This appeal is adjourned and to appear at the next sitting of this bench.
Well,
Was a senior advocate. He's not appearing. He's not appearing. He's then he's appearing as a senior counsel, not a solicitor.
No, but Advocate General, Deputy Solicitor General has the power to make private appearances also. So his designation power and also.
my lord, the next bench, I think, is the day after tomorrow, my lord.
Huh?
Next, this bench will sit again day after tomorrow, my lord.
Whenever it sits again,
But I'm praying for a little, by day after tomorrow.
let it appear, otherwise we do not know when we will sit again.
Well,
So then you pray for adjournment at that point.
Much obliged, Lordship.
Indeed,
Item number 4.
He's deputy president, but he's appearing to this. He's got the right.
Well, item number 4, I am appearing for the appellants in virtual, my lord. My apologies, I could not be at Shillong today.
Where are you stationed?
My lord, I am at Guwahati, my lord.
Yes. You are for the appellant.
My lord, I am from the appellant.
Who's for the respondent?
Mr.
I'm for the
Devnath,
respondent. I'm for the respondent.
my lord, even a physical hearing would have been more convenient for me because the record is bit voluminous, though the issue is very limited, my lord. It's on the issue of parity of rank and pay in the clerical trade in Assam Rifles, my lord. There are already judgments delivered in this extent, which are affirmed by the Supreme Court, that the clerical trade, my lord, the initial rank should be warrant officer. But then in Assam Rifles, my lord, half of them are designated as warrant officer, half of them are, my lord, including these petitioners, are still in the rank of Havaldar, my lord. So that is the limited issue, my lord.
So when would it be possible for you to go to appear physically and do the matter?
My lord, if your lordships are sitting day after tomorrow, my lord, I will be there,
But day after tomorrow, other matters are also there.
my lord. My lord, any other convenient date time.
Architect take the 12:30. The appeal is ready for hearing.
Yes, Your Lordship.
It is ready for hearing, my lord.
11th December, marked at 12:30.
My lord, deeply obliged.
All right.
Deeply obliged.
By consent of learned counsel for the parties, list this appeal before this bench on 11th December at 12:30 p.m. as the only matter in the list.
Deeply obliged.
From supplementary list, item number 1.
This is the only matter on the list. And this-
Wait, please, Your Lordship. No, my lord, as I was submitting, Your Lordships,
The other two matters are short matters.
Yes, sir.
Very short matters.
Just pass over for
my,
call the next one.
From the daily list, item number 1.
Yes.
Your Lordship, I've already filed my additional affidavit in this matter, Your Lordship.
Sorry?
I've already filed my additional affidavit in this matter, Your Lordship. Your Lordship can have this matter for hearing after vacation, Your Lordship.
Condonation of delay application is there.
Yes, Your Lordship.
That has been condoned, Your Lordship, with a cost of 10,000 or 20,000.
Condoned.
Has been condoned, Your Lordship.
What is this appeal about?
Your Lordship, here we are aggrieved by the order of the learned single judge, Your Lordship, whereby promotion was not considered, Your Lordship, with retrospective effect, Your Lordship.
Promotion was not considered.
We were promoted after on 2017, Your Lordship. However, we are seeking for a retrospective promotion, Your Lordship, to the next higher post, Your Lordship.
So there is no scope of any interim order.
No, Your Lordship.
The writ was dismissed.
The writ petition was dismissed, Your Lordship.
We will hear out the appeal
Your Lordship, yes.
because the order condoning the delay of the then Chief Justice says on production of proof registry is directed to number the appeal and list for admission. So this is for admission.
Lordship, yes.
It's for us.
Yes.
You are appearing for all the respondents.
Lordship, yes, for the state, Your Lordship. For the state.
Admitted.
Lordship, yes, all the respondents.
Yes. By an order dated 11th June 2024, the appeal was admitted. Full stop. By a subsequent order dated 6 September 2024, the appellants were granted leave to file an additional affidavit to bring certain facts on record. Next, today, on behalf of the appellant, time is sought by his learned counsel to file this additional affidavit. Paragraph. We are of the view that there is considerable passage of time after admission of the appeal and that the appeal should be heard out expeditiously, dispensing with all formalities. Full stop. You have already filed the additional
Yes,
affidavit.
Your Lordship.
Then why are you saying that I want to file an additional affidavit?
I beg to pardon, I've already mentioned, Your Lordship. I've already filed, Your Lordship, yesterday, Your Lordship.
Okay, you strike that out. You say the additional affidavit has been filed. And thereafter you write, there is no scope of any interim order. Next, we expedite hearing of the appeal, dispensing with all formalities. And next, advocate on record for the appellant shall file an informal paper book in this court. By 17th December
Lordship.
2024, serving a copy thereof on the respondent's advocate on record at least 1 week before the date fixed for hearing of the appeal. List the appeal for hearing 2 weeks after reopening of the court. After the Christmas vacation.
Item number 2.
Obliged, Your Lordship.
Milord, the state is in appeal, Milord, where the learned single judge has directed that the state should conduct a special examination for regularization of the lady supervisors who have been appointed temporarily, subject to regular selection, and the learned single judge has directed holding of examination for them and thereafter to take a decision, Milord. This is because, and on the premise on which learned single judge has passed the order, Milord, is that they have been serving for about 10 years. And on that ground, the direction has been issued, Milord. Their appointment order and all these matters, Milord, was very clear that they are temporary employees. Their appointment or employment is subject to regular recruitment, Milord. And we have given them the concession also that they will not be age bar, Milord. So this is a batch of matters, Milord. But first thing, Milord, is that there is some delay in filing the appeal, Milord. So condonation of the application is there and 131 days of delay is there.
So, Learned Advocate General, you serve on the respondent?
Yes, Milord. We will take steps to serve the.
How long should we adjourn it?
Your Lordship, kindly grant me 10 days time, Milord.
All right, list this appeal along with the miscellaneous application on December 4th.
Yes, Milord.
The advocate on record for the appellant shall take steps to effect service of the miscellaneous application on the respondent and file a service return report stroke affidavit of service. Then 5th, Fifth is all right? Fifth. Yes, call the past over.
This, item number 1.
Wait, Your Lordship. My Lord, as I was submitting, Your Lordships, my Lord, in the writ petition filed in 21, my Lords, the renewal was considered. There was a direction to consider the renewal on the basis of the submission made by the concession made by the, my Lord, Commissioner and Secretary and Commissioner of Transport. Jointly, they filed an affidavit. I have annexed, I'll take my Lord to that. My Lord, a direction was that was recorded, and direction was given expeditiously to take a decision on the renewal. Now, thereafter, necessary process was initiated, my Lord. Renewal was done. A fresh agreement, lease agreement was executed on behalf of the state by the Transport Commissioner and me, Your Lordships. That was executed in the year 22 for 3 years. Due to expire, my Lord, the license due to expire in May, 31st May 25. Now, when I was operating, my Lord, that tenure was cut short, my Lord, and an impugned letter was issued, my Lord, in June 2023. Only stating, my Lord, without citing any reason, my Lord, a unilateral decision was taken that the tenure of the license would be till 31st September 2023, my Lord. So I challenged these, Your Lordships, in 2023 by filing the writ petition. Now, during the pendency, my Lord, that impugned letter was withdrawn. And simultaneously, my Lord, what they did, Your Lordship, they had also withdrawn the enforcement options. So I filed the 24th, in 24, another writ petition, my Lord, praying for, my Lord, that the action is bad. The enforcement officials are to be posted, and they have opened up just 2 kilometers away another government way bridge. Now, my Lord, here, Your Lordship, learned single judge, my Lord, while deciding the issue, my Lord, taken into consideration, my Lord, all the 3 writ petitions, the one which was disposed of in 21, the learned single judge is of the view, my Lord, these have a hearing. So, my Lord, learned single judge taken up the writ petition, my Lord, order passed in the writ petition 21, 23, and 24, Your Lordships. And learned single judge, my Lord, basically dismissed the writ petition mainly on the ground, my Lord, that the way the settlement has been made by the Commissioner of Transport, my Lord, is not proper, and that he is not an authorized person to enter into an agreement, Commissioner of Transport. So my endeavor, Your Lordship, to show Your Lordship, first, my Lord, that was an issue in the writ petition filed in 23, my Lord. And my Lord, since the impugned order was withdrawn, my Lord, so by implication, my license was restored, there was no scope for making an inquiry, first thing, my Lord, because even the state government, my Lord, I have pointed out to Your Lordship, my Lord, at page 266, their affidavit, they have considered matter has become infectious. And this was not a public interest litigation. But even then, the learned single judge made an inquiry how it has been settled, and ultimately held, my Lord, on 2 grounds, my Lord, that the Commissioner of Transport is not the competent authority, and that in 21, court has never given a direction for settlement, but consideration for settlement. So on these 2 grounds, my Lord, say the very settlement is not correct. And on this ground, my Lord, dismissed both the writ petition filed in 23 and 24. So, my Lord, my first endeavor will be to show Your Lordships that the Commissioner of Transport is the competent authority, my Lord, to enter into the lease agreement. For this, my Lord, I will take my Lords to the rules, briefly to the rules of 2009, page 76, page 56, my Lord. My Lord, at page 57, my Lord, the relevant parts start from page 57, rule 3, my Lord. Rule 3, man. If you can read it. Yes.
Yes, my lord. 3, my lord, Rule 3. Installation of weighing device. The government may install and maintain by itself as many weigh bridges for the purpose of Section 144 of the Act, such places as it may think necessary, or may allow any private person, body or person, company, organization to install and maintain such weigh bridges on payment of lease amount to be determined in each case by the government after calling tender, your lordship. Provided that no lease shall be granted permission to any private person, body or person, company, organization, unless after fulfilling the criteria laid down in Rule 456 and these rules. And my lord, here I'll just emphasize one thing. The word lease, my lord, only occurred in section Rule 3. No, nowhere in the other provision, nowhere it said who will sign it on behalf of the government. It's silent. Nowhere, my lord. Now, if I can, my lord, for your lordship, we can skip, but these are the, my lord, criteria, because there is no dispute as regarding my criteria, my lord. I am skipping it. Now, 5, your lordship. Permission for weigh bridge at the satisfaction of Commissioner of Transport. Lordship will take note, my lord. Here, the Commissioner of Transport play a very crucial role, my lord. It depends on his satisfaction. It is not that he is nobody, my lord. 5. In considering the grant of permission, the Commissioner of Transport should satisfy himself that the proposed place for installing an operation of the weigh bridge on the National Highway State should fulfill the following conditions. A. Adequate parking space, lay-by facilities so as not to cause problem to the traffic congestion on the highway is available. B. That it is maintained in a safe and appropriate manner. C. That the proposed location is consistent with the public safety and convenience. D. The provision for offloading and access loading is available. Now, these are the criteria he should satisfy. 6. Commissioner of Transport to forward the application to the Secretary of Transport Department. After satisfying himself the application is complete and meets the requirement as laid down in aforesaid 4 and 5, the Commissioner of Transport shall forward the application with all required information to the Secretary of Transport for issue of permission. Now, my lord, here, my lord, it depends on the satisfaction of the Transport Commissioner. Then he, once he is satisfied, my lord, he forwards this application, my lord, to the Secretary of Transport Department. Now, my lord, Secretary for permission. Now, here it has not said, my lord, if it is required to be, my lord, done in a prescribed form, how the permission is given, that is not provided, my lord. My humble submission, my lord, it could be gathered from a situation where the permission has been granted, where it can be gathered from a situation as well, your lordship.
Or 3 years renewal was made.
3 years renewal was made.
Who issued the order?
My lord, there is a lease agreement. There is a lease agreement. Lease agreement was signed on behalf of the state by the Commissioner of Transport.
And the extension?
Extend both. Original lease was also signed, my lord. Original lease granting me license in 2017, that was signed by the Commissioner of Transport. Subsequent renewal, my lord, was made in 2022. That was also signed on behalf of the government by the
Rule 3 says
lordship.
by the government.
By the government. Now, my lord, I'll just come to this, your lordship. Rule 6 say, my lord, the application shall be,
Lease amount
my lord,
to be determined in each case by the government.
by that has been
That
determined.
means lease or lease amount
Lease amount, that has
by
been
the government.
by the government.
So whether the commissioner was authorized by the government,
No, I'm coming. I'm coming to it. No, that was done, my lord. That was done, my lord. Now, government here means your lordship. If I can take my lord to the, my lord, here what has happened, my lord, in 2017, tender was floated. Tender was floated, your lordships. I was the successful bidder. Now, my bid was examined by a committee. I was found the most suitable bidder. And the weigh bridge was settled, my lord. This is not in dispute. The weigh bridge was settled, my lord, at the lease amount of rupees 75 lakhs. It was settled at 75 lakhs. That was in 2017, my lord. Now, my lord, so far the lease amount, my lord, nobody has, state government do not have an issue, my lord. That license which commented in 2017, that's not an issue, your lordships. So nobody is questioning that. That was settled, my lord. Now, subsequently, when the extension was made, now, the extension or the renewal, the lease agreement, my lord, made on renewal, that was also signed, my lord, by the Commissioner of Transport. Now, my lord, 7, my lord, 7 deals with renewal of permission. Any permission,
Learned judge has dismissed your writ on the ground that he had no authority.
is not no authority.
That is
Number
the
2
only-
grounds.
That is the only ground.
This is one ground, and the other ground is this. In 21 writ petition was filed, my lord, seeking a direction to consider my application for renewal. And another ground held by the learned single judge is that in 21 in the judgment, we have never given any mandatory direction to the government to renew the lease. So I'll come to that, my lord. Now, first, my lord, I'll try to show your lordships, the Commissioner of Transport is the authorized person to sign the lease agreement on behalf of the government. Now, my lord, the 7 renewal of permission. Any permission referred to Rule 6 above shall be renewable every 3 years, and no such permission shall be granted or renewed unless proposal
We
grant.
understood, Mr. Advocate General.
Yes, Your Lordship.
Being a private contractor,
Yes, Your Lordship.
he is not supposed to know who's authorized by the government.
Yes, Your Lordship.
Now, there is a presumption, 114
Yes, my lord.
of the Evidence Act.
Yes, sir.
Perhaps most probably 114.
Yes, Your Lordship.
That whatever act the government does is presumed to have been done regularly.
Yes, Your Lordship. Your
So you
Lordship.
have to rebut that presumption.
Yes, Your Lordship.
He knew, and in spite of that, he took advantage of the irregular action, or he promoted that irregular action. Otherwise, if
Yes, sir.
someone gets a letter with a seal and side of a government official,
It is presumed that it is validly done. It is presumed
What is
that.
his fault?
Yes, my lord. So now, if I can show 2 things, my lord, that he knew that it is not by the government, my lord, because 2017, my lord, your lordship has seen Rule 3.
Yes.
Rule 3 says, my lord, that the government can set up as many bridges as it desires.
Yes.
First prayer, if your lordship would recall, the
No,
first,
there is no issue regarding that.
his prayer was that to dismantle the departmental way bridge also.
No, we are not into that.
Yes, my lord. So
Only
that
say-
part is over.
Yes, only-
Second part, my lord. The Rule 3, statutory rule says that it has to be by the permission of the government.
Yes.
Now, when the first lease agreement was entered, the lease agreement clearly said that permission of the government has been granted for setting up the way bridge. Second agreement does not contain the stipulation that the permission has been granted. It's clearly, and that part has been noted by learned single judge in the impugned judgment and order, my lord.
I'll satisfy you.
So therefore, to say that the person was not aware of the permission, my lord, because here your lordship, before you,
To be granted by execution of the lease.
in the recital of the agreement, my lord, in the recital of the first lease agreement, it is clearly and unequivocally stated that the permission has been granted by the state. In the renewal, my lord, which Transport Commissioner on his own and on the pretext of the order of the High Court passed that renewal, my lord, contrary to the statutory rules, there is no such word mentioned, my lord. And we have canvassed the second point, my lord. The Article 299 says, because Article 299 of the Constitution says that you have to pass the order in the name of governor, which is validly made, my lord. And that, if I can show the finding, my lord, because everything has been noted by the honorable learned single
Your
judge.
lordship, permit me, my lord. Those things I'll satisfy.
Your lordship kindly see
Permission and all, I'll satisfy.
the impugned order, my lord, because every aspect has been examined, my lord. Case 315, my lord. In fact, I would request your lordship to kindly see paragraph 10, 311. At 312, my lord, where the first order is passed by the learned single judge on 9th May 2022, my lord. 312, my lord. paragraph 4 of 9th May, my lord, the learned single judge record. Accordingly, it is directed the writ petitioner to approach the state respondent with appropriate application within a week, which is to be considered expeditiously, preferably within a period of 1 month from the date of receipt of the certified copy. Then thereafter, my lord, the Commissioner Transport on his own passes one order on 30th May 2022, my lord. The direction is to approach the state government, Commissioner Transport, who has no authority, my lord, at 314, and last paragraph of that order, my lord, dated 30th May 2022. Therefore, in order to comply to the direction contained in the Honorable High Court order, petitioner is hereby directed to pay renewal so as to ensure signing of agreement. So, he writes, he says that now I am renewing the agreement. And Your Lordship, kindly see 316 after noting all these aspects, my lord. 315 last 3 lines, my lord. It is noteworthy to mention that impugned letter dated 14 July, reference has been made of 30th September, which conveyed the decision of the government with regard to renewal. This is pertinent in view of the fact that Rule 6 of Weighbridge Rules 2009, it is the Secretary to the Transport Department who is the competent authority for issuance of permission, in as much as Rule 3 and 4 vest the power of installation of weighbridge and permission to the grant establishment to private entities with the government, my lord. Your Lordship has observed that permission of the government is required, my lord. Now, paragraph 13, my lord. In the factual situation as portrayed above, it is to be first noted that initial lease agreement was executed on 17/11/2017. I will pause here for a moment, my lord. When 17/11/2017 lease agreement was granted, it was after the tender, my lord. And the tender amount was 30 lakh rupees, my lord, and 22 also the Transport Commissioner is granting lease to him on the same amount, my lord. No tender, nothing, my lord. Paragraph 13. As per the stipulation of Rule 7 of Weighbridge Rules, a permission granted for installation of weighbridge under Rule 6 is renewable every 3 years. In the case the petitioner admittedly the lease agreement of expired on 6 December 2020, my lord. If the lease has expired, my lord, in 2020, the renewal could not have been granted in 2022, my lord. And on non-renewal of permission has filed, my lord. After noting all this, my lord, the learned single judge again notes the letter of the Commissioner of Transport dated 20th May, and kindly see, my lord, one line, paragraph 318, page 113. The learned single judge has taken note that in inviting reference to the letter of subject cited above, I am to inform that Honorable High Court of Meghalaya, Ceylon-wide judgment and order dated, has directed to renew the agreement of weighbridge. This was...
You know, Mr. Advocate,
Yes,
in a lease matter, there is very little difference between fresh lease and renewal.
Yes, Lordship.
There is very practically...
Yes, Lordship is absolutely right, my lord, but the issue, it is a case of statutory lease.
We are not saying that the government weighbridge should be demolished.
Yes,
we are not considering that.
Your Lordship is considering whether this 2022 lease is validly executed and in terms of statutory rules or not.
When ostensible authority is there, means that he can presume that he has the had the authority, the commissioner had the authority.
This presumption is rebutted, my lord, on 3 things, my lord. First, my lord, that commissioner did not have the authority which is there in the statutory rules, my lord. Kindly see Rule 3 itself for a moment, my lord. Rule 3, he cannot feign ignorance of a statutory law.
Rule 3 says government. Government has a list of authorized persons.
And the government has the Transport Commissioner is not the government, because a letter which was addressed to him by the Transport Commissioner says that your application has been forwarded to the government. That was also noted, my lord. The letter is addressed to him, and that letter clearly says that your application has been forwarded to the government, my lord. Kindly see. That letter is at 314, my lord, 30th May. 314, my lord, the learned single judge. And this letter was addressed to him also, my lord. 30th May. This letter has been forwarded to the government. He says in the middle of page, Office of the Commissioner of Transport, Shillong, thereafter received the copy of petition on 11th May, which has been processed and forwarded to the original to the Transport Department on 11th May 26. And a copy is marked to him. So he knows that it is the government, my lord. And kindly see the first lease deed document also, my lord, where the government has granted permission. And if your lordship, this plea of petitioner appellant is accepted, my lord, that officer who is not competent and authorized has entered into the agreement, then the issue which will be there before the government, that the government will not be bound by the action of the officers who are not competent and legal.
No, but then you have to show some action taken against the officer also.
Yes, my lord, that your lordship is right, that we have to show.
Nothing is done against the officer, the private individual is victimized.
Your lordship, here is a case where private individual entered in because material show, and the learned single judge has that entered into some sort of collusion.
So was the commissioner asked to explain why he signed?
Yes, lordship is right that he was immediately removed from the post, my lord. The new transport commissioner has been appointed. Why did he? Because all these aspects are there. Your lordship, kindly, public money is also involved to extent that when the rule says that every weighbridge will be settled by tender. In 2017, when we settled the tender, we invited the tender and we gave it for 30 lakh rupees. In 2022, again, he is asking for renewal at the same amount, my lord. No tender. So all these aspects, my lord, has been taken into consideration, my lord, by learned single judge. And kindly see the rule which is there at 319, my lord, page 319. The government may install and maintain by itself as many weighbridges for purpose of section 144 of the Act on such places as it may think necessary, or may allow any other private body, person or body or persons or company or organization to install and maintain such weighbridges on payment of lease amount to be determined in each case by government after calling tender. And, my lord, provided that no lease shall be granted permission to any private person, body or persons, company or organization unless after fulfilling all criteria as laid down in Rule 4, 5 and 6 of these rules and permission from government in transport department is obtained.
But Mr. Advocate General, this is your own internal problem. Whether
Yes.
he has called a tender or he is not called a tender or entered into a private treaty or without authority engaged the contractor.
Yes, my lord.
But then unless his complicity is shown that in some
the
kind of
process.
irregularity,
Yes, my lord.
how come an innocent person taking
Yes,
a renewal sealed, stamped and signed by a government official to be not genuine?
Why, my lord? Kindly see the first renewal, first agreement.
We will continue tomorrow, Mr.
Yes, I will continue tomorrow.
Hopefully, think, my lord, these are not correct. Lordship
I
will
will
give you-
place everything. I will place everything.
We have observed that there is a presumption working in your favor. That act of the done is done regularly. So let him revert, then you answer.
I'll answer. Because, my lord, there is a policy decision clearly spelled out who will sign the lease agreement. It is the Commissioner of Transport. I want to highlight, of course, my lord, after Lordship, he clarifies the point. And those submission, my lord, in 21, Commissioner and Secretary came before the court and he said we will do the renewal as per the policy decision and the statutory rules.
No, my lord,
That is very
I will
important.
place what my friend is saying, my lord. He is not an innocent person, which documents will show, my lord. And document will show. Document will show.
We can gauge that, but There's nothing on record.
I'll place, my lord. I will try to
The other thing, my lord,
And there,
same person, he has settled other railway bridges.
My lord,
Other railway bridges are still functioning, untouched.
No, no, we are
Right,
taking
so, my
action
lord.
against
That's why, my
everybody.
lord, I think I need to point out all these things.
we are taking action against you.
Lordship will come up tomorrow.
Yes, yes.
List is settled for further hearing.
Tomorrow.
Marked at 12:30 tomorrow. Tomorrow, marked at 12:30.